All right, good morning, counsel. All right, back on the record in the Simpson matter. Mr. Simpson is again present before the court with his counsel, Mr. Ullman, Mr. Shapiro, Mr. Cochran, Mr. Douglas, Mr. Bailey, people represented by Ms. Clark, Mr. Darden, and Mr. Hodgman. All right, counsel, we have just a few matters to dispose of before we reach our opening statement stage. Counsel, yesterday the jurors, when they retired, one of the jurors handed the bailiffs a note for the court, and they were just curious as to whether or not the court was going to allow them to watch the Super Bowl this weekend, and I've indicated to them that yes, they can, and that we would arrange their visitation schedule accordingly. So I take it there's no comment on that. All right, Mrs. Robertson, would you create a file for juror notes, please? All right, first issue to be resolved is the defense motion to allow Mr. Simpson to briefly address the jury during the course of defense counsel's opening statements. All right. Certainly.
Your Honor, the first objection interposed by the people is that this has never been done before. And we have located at least two California precedents where it has been done before. The first came in probably the first case of the century, which was the trial of Clarence Darrow here in Los Angeles for jury bribery. Even though Mr. Darrow was represented by eminent counsel Earl Rogers, he was allowed to directly participate in the presentation of the opening statement and closing argument to the jury. The second example came in 1972 in the trial of Angela Davis in Northern California, in which, although she was represented by counsel, she also was allowed to present opening remarks to the jury. So it's not a question of proposing something that has never been done before, as to which there is no precedent. The second objection raised by the people is that they will be deprived of their right of cross-examination. And I think that really misconceives what is being proposed here. First of all, Mr. Simpson will not be testifying, and the standard instruction given to the jury with respect to all of counsel's opening statements, that they are not evidence and not to be considered as evidence by the jury, will certainly apply as well to Mr. Simpson's opening remarks. But what is being proposed really is not a presentation in the traditional form of an opening statement. What we are simply proposing is that Mr. Simpson be allowed to introduce himself to the jurors, to introduce the defense team, the lawyers who are representing him, and to simply reiterate his plea of not guilty. Now, of course, the prosecution has no opportunity to cross-examine a plea, and we believe it would be quite appropriate for the jury to hear the plea of not guilty that sets this trial in motion directly from the lips of the defendant. This is not really all that remarkable a request. What it really seeks to do is to focus the attention of the jury back where it belongs in the midst of all of this hoopla, and that is on the defendant who is on trial, to remind them that what's really at stake in this trial is one man's freedom. We want them to see who that man is. We want them to hear from him very briefly in terms of introducing himself, introducing counsel, and reiterating his plea. The second part of the motion simply addresses a physical demonstration that is routinely done in trials, routinely done by the prosecution as well as the defense, and again would not involve any testimony but simply a preview of evidence that will be presented in the course of the trial.
All right, Mr. Ullman, it was represented to me that preview would be merely of the defendant's knees regarding certain surgeries that he has undergone as a result of his athletic career. Is that correct?
Yes, that is correct.
All right. And have you contemplated the security desires of the Sheriff's Department that they have their bailiff within close proximity of Mr. Simpson at the time that this is done, and how you would do that in a manner that would not convey a unnecessarily negative message to the jury?
Well, that was the reason we brought this up in advance, Your Honor, so that adequate preparation could be made to post a deputy on this side of the courtroom if that's necessary, but it simply involves him walking from one side of the courtroom to the other.
All right, and unfortunately, the logical place to do that is right by prosecution counsel there. So we have that proximity problem as well. Have you contemplated the logistics of our unfortunately small courtroom?
Well, if the prosecution wants to just switch sides with us, we'll be glad to move over to this side of the courtroom. But
you've asked for that already.
I don't think that they have any concerns about being in proximity of the defendant.
Well, I just have concerns about that as a security concern is all. All right. Thank you, counsel.
Could we have just a moment? I'm informed Mr. Cochran has discussed the issue with the bailiff, and there's no problem with the bailiff being in proximity while Mr. Simpson addresses a jury or displays his need.
All right. I'll hear from the people.
Thank you, and good morning, Your Honor.
Good morning.
First of all, this is not an opening that counsel proposes. It's simply an attempt to capitalize on whatever defendant's star appeal currently is with the jury, and to get him to have close proximity with them to impress them. What is the probative value of a scar? What does it prove to this jury in terms of his physical capabilities on the night of June the 12th, 1994? It proves nothing. In fact, we all know that on the morning of June the 12th, he was playing golf. We also know that within weeks before the murder, he made an exercise video. So the probative value of that scar is nil, and the misleading nature of presenting that scar to the jury is great. The inference that the defense will seek to draw from that scar is that he was incapable of certain physical acts. If that is what they intend to present, that's fine. Let them present testimony that is capable of cross-examination. But to have the defendant essentially testify before the jury without taking the witness stand and being cross-examined is inappropriate. The cases in which the defendants have been able to address the jury in opening statement in previous occasions have been cases where the defendant was acting in pro per. This defendant is not in pro per. He is represented by many attorneys. If he desires to testify before this jury, then let him do so as all witnesses do, on the witness stand, and be subject to full and complete cross-examination. Case law is completely in favor of the people's position in this regard. People v. Perez, 216 Calap 3rd, 1346, in which the defendant requested to be allowed to exhibit his tattoos without being sworn or giving testimony. The court refused his request and ruled that the exhibition of the tattoo would be testimonial if offered, to impeach the testimony of an undercover officer, and essentially that's what the injuries now being proposed to be displayed to the jury is being offered to show, that he could not, in fact, commit certain acts that he is charged with committing. It's testimonial in nature. Let's make no mistake about that. What is the purpose otherwise of demonstrating the scar or of talking about or showing the jury what he can and cannot do? It's going to give him the ability to limp up to the jury box, get close to the jury, and try and impress them with his physical presence. That there's nothing appropriate and there's no legal benefit to this in terms of what is appropriate in a court of law. If the defendant would like to testify, that's fine. But to do this and then shield himself from cross-examination, say, don't ask me any questions, I just want to get up there and show you something. I want you to draw inferences from this. I want you to take evidence from this without being subject to cross-examination is entirely inappropriate. The people would not be entitled to do that because there would have to be a foundation laid. People v. Perez makes that very clear. It indicated that it would be irrelevant as demonstrative evidence as well, which is what the defense claims it's proposing here, although the people dispute that, and really it's a testimonial in nature kind of thing they're proposing. Nevertheless, even if it's demonstrative, the court in Perez ruled that because the defendant had laid no foundation for the admission of the evidence, it was appropriately denied. In this case as well, what the defendant proposes to do requires either his presence on the witness stand or some testimony from the witness stand to lay a foundation for its admission. To simply display something to the jury without any evidentiary basis gives them nothing reliable and nothing of probative value. It is only a blatant attempt to impress the jury with his charisma and star appeal. That is not an appropriate vehicle in the opening statement. Let me indicate also that the case of People v. Wong held similarly. People v. Wong, the trial court indicated that it was improper to have the defendant exhibit his arms to the jury without first being sworn as a witness. In that case, 35 Calap 3rd 812. The defendant in that case wanted to indicate that he was not an addict, he had no track marks on his arms. The trial court refused to allow him to do so unless he subjected himself to cross-examination. On appeal, the court was upheld, and it was determined that if it was a testimonial, if it was being offered as testimonial evidence, it was properly refused when the defendant declined to be sworn as a witness and subject himself to cross-examination. It also ruled that if the offer was a demonstrative one, then the trial court was justified in rejecting it on the basis that it was irrelevant. As I've indicated to the court yesterday, his arm was being offered on May 12th, 1971, to show the condition of his arm on June 5th, 1970. The defendant's condition today, or the existence of that scar, without laying a foundation as to what the significance of that scar is and how it impacted on his physical capabilities, is something that exists without foundation. It has no probative value in and of itself. If the defense wants to do it as part of an opening statement, they're going to have to also proffer something that lends it some value in terms of probative value. What I mean by that is they can offer a photograph of the defendant's knee, but simply holding a photograph up isn't going to get them very much, shouldn't. But the defendant, in terms of its evidentiary weight, because what does that mean in terms of his physical capabilities, or his limitations? Having the defendant as well get up to tell the jury that he's not guilty is another attempt, blatant attempt, to have the defendant address the jury without being cross-examined. It's like issuing a blanket denial and then saying, you can't ask me any questions. In a court of law, Your Honor, when a defendant seeks to testify and issues a blanket denial, that opens the doors to cross-examination as wide as they can go, and the people are permitted very far and wide-ranging cross-examination. The defendant seeks to do that in this case and preclude all cross-examination. He seeks to protest his innocence and yet not allow anyone to ask him any questions. That is entirely inappropriate. The court, I'm sure, is very well aware of that. If he were in pro per, he could get up and say whatever he wanted to. He's not.
All right, what's your page cite on People v. Wong?
835.
What's your page cite on Perez?
And then 1348 and goes on to 1349. The holding, 1348 and 9 give the factual exposition, 1350 gives the ruling.
All right, any other comment? Thank you. Mr. Ullman?
The suggestion that a plea of not guilty subjects a defendant to cross-examination is simply not the law. The plea of not guilty is what sets this trial in motion and puts the burden on the people of proving guilt beyond a reasonable doubt. It's really incredible to suggest that somehow the jurors will be prejudiced by actually hearing the plea of not guilty from the mouth of the defendant himself. Actually, the only person who can enter the plea is the defendant himself, and that plea is what sets these proceedings in motion. And we believe it is quite appropriate and does not open up any doors to cross-examination, simply to have the jury observe the defendant and hear his plea of not guilty from his own lips. The suggestion that this is some sort of ploy to capitalize on the defendant's charisma or celebrity status, it's just the opposite. It is just the opposite. We do not want this jury to view the defendant in terms of a celebrity. We want them to view him as a human being. And that suggests the greater need in this case to do it, because there is just so much starstruck quality about this whole proceeding, and we think it would be very healthy to remind everyone, especially the jury, that what's at stake here is simply the liberty of a man, a human being, and here he is, O.J. Simpson. In terms of the lack of foundation for the physical capability of the defendant, that will be presented in the course of testimony. Obviously, the opening statement doesn't present all of the evidence. It's a preview of what is to come, and this is an important part of the evidence that we would like to preview for the jury. When it is presented in the course of trial, there will be foundational testimony from Mr. Simpson's physician as to his physical capability to corroborate the physical demonstration.
Well, when you say demonstration, now you got me scared. Is this an exhibition? Exhibition or a demonstration?
Exhibition.
Two different things.
Right.
Okay. Thank you, counsel.
Thank you.
All right, I've reviewed the cases cited by the people, and the only cases that I could find that were of interest were a case out of New York and a case out of the Supreme Court of Mississippi that dealt specifically with the request of a represented client to address directly a jury. The motion to allow the defendant to directly address the jury will be denied. The motion to allow him to exhibit to the jury his knee injuries or the result of the scarring and the surgeries will be allowed. All right, counsel, we need to resolve then the last remaining issues on the exhibits, and we'll be prepared to go forward with opening statements. Mr. Douglas.
Thank you, Your Honor. Good morning. Yesterday evening, Your Honor, we were attempting... One moment, Your Honor. Yesterday evening, Your Honor, we were discussing the possibility of making alterations to the SOC timeline chart, of which there was an objection. As the court will see, we have altered the offending language to reflect the details and circumstances of a report that was part of an analyzed evidence report that I'd like to submit to the court and which I have already given to opposing counsel. What it says basically, Your Honor, is that there is a notation referring to different pieces of evidence. There is a notation for socks, navy blue/black. There
Is
is,
the June 29th report?
this is a report, Your Honor, if I may approach?
No, just answer my question. Is it the June 29th report?
Yes, it is. And it talks about there being, quote, dress socks, semicolon, blood search, paren, none obvious, close paren. And we would submit, Your Honor, that this is in fact a fair reflection of what we think the evidence is going to show. We would submit that that chart is not unduly prejudicial, and we would submit that the court should overrule the objections and allow the admittance of that chart.
Who was the author of that report?
This refers, Your Honor, this document apparently was prepared for the split hearing. It's Peoples 2 at the split hearing. And Yamauchi, Kessler, and Matheson each testified about the process by which they took out different pieces of evidence and examined it. And this was a document that was prepared specifically for that hearing.
All right, that doesn't answer my question.
Who prepared the report?
Who prepared that report?
Michelle Kessler, Greg Matheson, and Colin Yamauchi.
Was that the index that was prepared, the evidence index?
It says summary of analyzed evidence by analysis performed. That's the title.
Okay.
It's Exhibit 2 at the split hearing. The remaining objection, Your Honor, would be in response to the concerns about the videotapes and the scenes that were reflected of different officers walking through the crime scene at various times. We have now obtained the remaining tape recordings, and Your Honor, there was a misstatement yesterday. The scenes that were shown in the tape that has been given over to the people are not scenes that were taken from CNN, but rather they are a collection of different tapes that were received from different local news media, so that for us to introduce these different snippets, if you will, at trial, we will simply be able to lay the foundation by subpoenaing and bringing in to testify those operators of, I think it's local channels 5, 7, 11, and 13, from whom these particular snippets were culled. That tape has now been provided to the court, and that tape has also been provided to the people. We now have the tape from San Francisco that had 2 other blips that were not shown on the first tape. I am told by Mr. Hodgman that the people would continue to maintain their objection. So what I propose, Your Honor, is that the court allow the showing of the scenes that were displayed yesterday. They are scenes, Your Honor, that are very capable of being authenticated. In many ways, it is self-authenticating. In many ways, they are authenticated because there will be an evidence or a police log where each individual who comes onto the scene first checks in with one of the police officers that are there. That log will be an item of evidence, and it is possible by showing the scenes and having those depicted there testify to establish clearly when the various pieces of scenes were taken and what sorts of things were occurring. It is true, Your Honor, that it is the people's crime scene. It is true, Your Honor, that they themselves do not have a videotape of the crime scene. There are certain discrete acts that are going on. For example, Detective Lang measuring a certain location. For example, you see criminalist Fung placing down particular evidence tags. You'll see detectives walking through, Detective Van Adder and Rogers walking through, and quite clearly the sheet is there because the body has been removed, but the sheet remains, and it shows, Your Honor, the sort of sense that we are going to depict in words. It helps to provide a visual context to the words that Mr. Cochran is going to speak. He is going to discuss how the evidence will show that there was contamination of the crime scene. We would then hope to show pictures that demonstrate, that reflect, the contamination of the crime scene. They are going to offer evidence, I suppose, Your Honor, how the crime scene was not contaminated. Perhaps they'll show that when these scenes were shown, all of the items of evidence had been collected. Perhaps they'll show, or they'll offer evidence that when these scenes were shown, it was the next day or the third day after. That is the risk that we are going to take by the statements that we are going to make in our opening statement. But whether or not there are the visual reflections of certain words, Mr. Cochran, I think quite properly, will be able to discuss and to speak about how the crime scene was contaminated and how we contend these scenes are simply a small reflection from the only live record that is available showing the conduct of Detectives Van Adder and other detectives at both the Rockingham and Bundy crime scenes on June the 13th. Your Honor, that I think is the end of my objections to the charts that the people are going to offer and my explanation to the items that were remaining yesterday.
Thank you, Mr. Douglas. Ms. Clark? I'm sorry, excuse me, hold on a second. All right, Ms. Clark?
I thought that the court had concluded its ruling yesterday with respect to the tape. Mr. Cochran made a motion that when a ruling is issued, we not re-argue it, and we all agreed to that.
But what I said yesterday is that if the defense makes the videotape available to you, and after reviewing the tape, you still maintain, I mean, who knows, after looking at it, you might have changed your mind. Now that you've had the opportunity that's been brought here, what's your position?
We haven't had a chance to see it. They just gave it to us this morning when we walked into court.
How long are these videotapes, Mr. Douglas?
Your Honor, the first tape was played, I think, in its entirety yesterday. The second tape, which is we got this morning from San Francisco, is approximately 25 to 30 minutes long. However, a lot of that is a press conference by police officers. The first 5 or 10 minutes contains the 3 clips that we wish to use in opening today.
The first 5 or 10 minutes of
Yes.
this?
In addition to the ones that we showed yesterday.
The same problem exists now as it did before. We don't have a foundation as to time, and time is very important. The bloodstains were collected at a certain point, and that's not established with the tape. Secondly, there's a counter at the bottom of that tape that's very misleading because it looks like all of these different actually pieces of tape were one continuous shoot, which is not the case, as counsel even concedes. There was considerable editing done to that tape, and the people maintain their objection.
All right, don't you think we ought to at least look at the first 5 or 10 minutes to see if you still do?
I will, certainly, Your Honor.
All right.
I'll be glad to. Let me go on to the other exhibit. With respect to the SOC timeline,
Yes.
what Mr. Douglas has represented to this court is very misleading. And I confronted him this morning, and I explained to him that on this is not a business record, I should indicate to the court, first of all. It was a chart prepared specifically for the Griffin hearing and the blood split hearing, actually, at my request, because I wanted to see exactly what they planned to do with all the items of evidence and what seemed to be sufficient for a split, what did not, what was capable of PCR, what seemed to be capable of RFLP. In the box-marked comments, it shows blood search because that is what they planned to do. It had not yet been done. These are navy blue to black socks, which, if you look at it with the naked eye, you're not going to be able to see anything. It was scheduled for a blood search, and it was put down that none was obvious because on a black pair of socks, you're not going to see blood. It's going to be, at best, you might see something wet, but after a period of time and it dries, you won't even see that. So it was scheduled for a blood search, and what Mr. Douglas has on this chart is very misleading because it indicates that they have already looked for blood and that none is obvious. This is exactly the problem. Is that the jury is, and if Mr. Douglas had spoken to Mr. Matheson, he would tell him. We put it there, as many of the other items listed in this comments column, as a prospective plan. You can see on this list, it says just above it, the item number 12, swatch, RFLP possible And on previous items, it shows RFLP would consume PCR only. It's very obvious what this is. They're talking about what is capable of being done or what they plan to do. Not that it's been done, it hadn't been. So what council has put there is, again, completely misleading. It's the opposite of what occurred.
All right, let's take a look at the videotape and see what's there.
May I also request leave of the court? There was one chart we had not yet seen that we only saw a Xerox copy of. I wanted to address the court further on it, and I think I can do that better if I have the chart in front of the court. That was the chart entitled Deceptions, Distortions.
I thought you said you had no objection to that.
I had lost my copy of it at the time, Your Honor. There is language on it that I wanted to object to, not the entire chart, but certain language on it, and I need to confirm that that is on it. If it's not, there will be none. But that is the problem with not having everything in court on Friday as the court
Counsel, is
requested.
there a reason you didn't tell me that you didn't have it in front of you when you asked me to rule on that?
I apologize to the court. I thought that...
I mean, I can't keep doing these things over and over and over again.
I'm only asking leave to see the chart as it currently exists. I have not seen the final hard copy. All we saw was a rendering on an 8 by 10 piece of paper. I would like to see what the final chart says.
Mr. Douglas, do we have that available?
We're looking around.
I have it, Your Honor. The chart is being mounted right now and will be picked up this morning. But it just mirrors this particular chart.
Does the court have a copy of this?
No.
Do you have an extra copy?
No, that's the only one.
All right, would you hand that to Mrs. Robertson, please?
I want to address the court on certain aspects of this chart.
Your Honor, we could put it up on the envelope.
Well, that'd be great. Let me first indicate, with respect to the first entry...
Hold on, I can't see the entire chart.
You can't either, okay.
No.
That's good.
All right. Wait, focus that a little.
With respect to the first entry, Mark Furman and the gloves, it indicates plural. At no time did Mark Furman so testify, and the chart is misleading with respect to that language. The people object to the use of the plural. That never occurred. Secondly, Van Etter warrant. The search warrant and the circumstances of the search are irrelevant to the trial before the trier of fact. That is a legal issue that the court rules upon that is improper to raise in opening statement, let alone in trial. I would further mention to the court, I thought the court ruled that Mark Furman could not be mentioned in opening statement.
That's correct.
And the people object on that basis as well. Furthermore, the Ron Phillips statement to the coroner. We're kind of not following procedure, but we're kind of asking a favor. A statement lifted out of context that is hearsay from a transcript that was issued by the coroner, not a statement made, not a report made by Ron Phillips, and is misleading and confusing on that basis.
All right. All right, Mrs. Clark, before you get too much further, counsel, this is an argument. This is not an opening statement exhibit.
Good morning, Your Honor.
Good morning, Counsel.
Your Honor, in this matter, it was my understanding yesterday that the people had an opportunity to look at everything. We did show this to them. And Ms. Clark indicated she had no objection. We don't want to be argumentative. This was passed, we thought, out of an abundance of precaution, if the court pleases, because we anticipated that she might change her mind. We have another chart, which I think the court will find hopefully less argumentative. I'd like for the court to take a look at it. I think this is what this is basically is a summary of the conduct. And I wanted one other query of the court with regard to Mr. Furman. The court did not say we could not talk about Mark Furman. I understand in opening statement what you indicated was that with regard to the Kathleen Bell incident, I think you said, but you never said we couldn't talk about Mark Furman. Is that my understanding?
That's correct.
Okay, I want to make sure that was clear. May I show this to Mr. Hodgman and then give Your Honor a copy of this, what we proposed? Thank you.
Is this a change to this document?
Yeah, it's a change to this document. You want to put it up there? Should we put it up for you? Let's put
Please.
it up. You got one? Okay, what's up now? With regard to these items, the court will recall that as part of the exhibits, we will have a video clip of Detective Furman. If Ms. Clark objects to the use of the words gloves, I will stipulate to strike, make it glove, but we still are going to play that clip. With regard to Detective Phillips, we actually have a transcript. We passed this yesterday. That's already coming in. We don't want to take any out of context. People will be able to see exactly the transcript, so nothing's taken out of context. With regards to Detective Van Adder, where the statement is made that Simpson had left on an unexpected flight to Chicago. What we're talking about is not relitigating the issue, the court pleases, of the entry, but to indicate that in the very first contact with the criminal justice system at 10:45 on 6/12, an untruth was told. That in that warrant, under oath, they did not tell the truth. And we have that, and you saw yesterday Cato Kalin's statement. Your Honor, with regard to securing, documenting, and preserving the crime scene, everybody has been very much aware of that the trainee, Mazzola, was her third crime scene, was basically the officer in charge there. With regard to the Bronco, we've litigated this. Counsel has known for some time. We've made it in as innocuous language as we can that they failed to give that special care for evidence presentation. We showed all this yesterday, Your Honor. They went through it. They had no objection. The DNA testing, we've said consistently. They can talk all they want about DNA. But all the DNA evidence passed through the LAPD before it went to any other lab. And we think it's our right to talk about that. We have a chart that we've already passed on of the OJ's blood vial, and this mysterious blood vial and its saga, where it went, instead of being booked appropriately. And then finally, the question of the socks, whether or not there was none obvious in the socks. I disagree with my learned adversary that blood is red, albeit dark red. It's not black like socks. And you would be able, I suggest, to see it. And I think the question is, if the prosecution thinks that they have a theory, and if we don't agree with that theory, they think they're always right. That's what a trial is about. That's why we're here, Judge. They're not always right. That's why they lose cases sometimes. And so they're not always right. The jury will make that determination. And this idea of protecting this jury, that's what you're going to do. We're not, you told us yesterday about doing our jobs. And that's when the system works best, Your Honor, as you well know. You do your job, we do our job, they do their job. We don't need Ms. Clark to do the job for the jury. They'll do their job, and you'll do your job. And I promise we'll do our job, Judge, and that's what you ask us to do. That's all we're trying to do here. This is a man that we have contended from the very beginning is wrongfully accused. And they are in for the fight of their lives. And so this is not any game. And so we're very serious about this. We don't want to be argumentative, and we want to just spell out. And we looked at this last night. Even though she passed on this, we think we spelled this out, and I think it addresses all of the concerns, Your Honor. And I think that certainly an opening statement, one can't be precluded about what our theory of the case is in good faith. And so what we're doing now is much more than usual, Judge. They're having a total preview of the things we expect to use.
All right, let's see the videotape as well.
Thank you.
Let me see everything that I have to consider, and then I'll rule.
I haven't addressed the new chart, though, that they just put up.
I'd like to see the videotape. Thank you. Does this contain any,
No, Your Honor, this pretty much starts where the other one left off yesterday. The bodies have been removed, but the coroner is still there, and Mr. Fung is putting down his tags.
Mrs. Robertson?
Clips that we wish to show in opening. There's a little
Right.
more after this, but
Stop the tape. All right, Ms. Clark, I'll hear your objections.
First of all, with respect to the videotape, Your Honor,
Yes.
again, the same foundational problems we had with respect to time. We don't have the authentication in terms of the timing, and that's critical in terms of the evidence collection. The inference that the defense will seek to draw is that all of the evidence collected by LAPD was contaminated in some manner by the method, by the actions that are shown on the tape. If the evidence was already collected by the time these people are shown in the positions shown in the video, then there is in fact no impact, and the inference that they're seeking to draw is directly misleading to the jury. And that is one thing that in opening statement neither side is permitted to do. The people are not attempting to tell the defense how to try their case. The people are asking this court only to make sure that the jury is not misled, so that they get the truth, so that they understand what the evidence really is, not spin and not distortion and not half-truths or statements taken out of context, but the truth. And the problem with a video such as this one is that we have no way of knowing when it was shot, and the inference that the defense seeks to draw from it may be completely false, in which case the jury begins the case with a total misconception about the conditions under which the evidence was collected. And that is a very damaging thing, and that's why the defense, of course, seeks to do it, I understand. But it's not the appropriate thing to do. The jury deserves to get the truth and understand what the evidence really is.
All right, do you want to address the other issues, the SOC chart and the conduct chart?
Yes, the conduct chart, I think the SOC chart I have, Your Honor, I've addressed that. That is, again, totally misleading with respect to blood search. With respect to the chart, now the new one is even worse than the other. First of all, it repeats the misleading and completely false inference drawn about the blood search. They seek to argue in derogation of reality, in derogation of the truth. The truth is that it was scheduled for a blood search. What they seek to infer from this is that it was already conducted and none was obvious. And that is exactly 180 degrees opposite of the truth. So that is a complete falsehood. With respect to Mark Furman and the gloves, again, it's false. They state, they put on the plural, which was never stated by Mark Furman. They take his statement out of context. There's an extensive colloquy between himself and counsel in which he refers to one glove that he saw at the foot of Ron Goldman, and he says that repeatedly. And yet, taking one statement out of context, they seek to draw inferences from it. It's argumentative. It's not an opening statement, and it's misleading and unfair because it is taken out of context. The same would go for Ron Phillips to the coroner. Of course these are taken out of context. How could counsel argue to the contrary when you have a lengthy transcript of statements that have explanatory information both before and after? You have A and you have C, and you take out B. And that's what counsel has done, taken everything out of its proper context and stuck it on a chart. And again, it's argumentative. With respect to the Van Adder warrant, that statement is irrelevant. We're talking about language in a search warrant. That's appropriate for the court to rule on. That's not appropriate for a jury to be presented. The jury has to be the trier of fact to determine whether the defendant is guilty or innocent, not whether the search was proper or improper. That is a legal argument that goes to the court, not to the jury. That statement is inappropriate and it's argumentative as well. With respect to preserving the crime scene evidence, the defense, if they are saying the trainee is Andrea Mazzola was not in charge. She was a trainee who was being supervised by Dennis Fung. So this is false. This is a false statement if that is who they are claiming was in charge of the crime scene. That is untrue and misleading. I thought that the court's ruling pertaining to Mark Furman was that neither side could mention him. That was just Kathleen Bell.
The Kathleen Bell impeachment issue.
Okay. With respect to may I have a moment, Your Honor?
Certainly.
With respect to the items, failed to give special care, that's misleading as well. That's put in quotes as though it comes from a manual of some kind, which we know is not true, and it's argumentative. Yes, it's true, all evidence passed through LAPD. No objection to that. With respect to all blood not accounted for, that's argumentative. We haven't seen any evidence of that. If counsel thinks they can lay a foundation through the course of this trial, that's certainly appropriate for argument, but it's not appropriate for opening statement. And again, it's argumentative. I'm just waiting, is the court?
All right, are you finished with your comments?
Yes, Your Honor. I'm
All right,
finished.
thank you. Mr. Cochran. Counsel,
Thank you, Your Honor.
I think we need an air traffic controller for the lawyers
We do,
here.
Your Honor. We will be patient, Your Honor, at all times. Your Honor, in this regard, first of all, let me again point out, this is an opening statement, Your Honor, and whereas they have their theories, and we have not said they shouldn't have their theories. We think we have the facts, but certainly contingent upon that, we have certain interpretations of what we think the evidence is. As the court has so correctly stated, we are permitted to talk about those things. If you look at this chart, sometimes people shouldn't object if they have nothing to say. And in this instance, Your Honor, the issue, I already conceded with regard to using the word gloves. I don't want to mislead anybody. We'll take the S off. With regard to Detective Phillips, Your Honor, we have the entire transcript that we're going to have available. The court's rule, we can use that. With regard to Detective Van Adder, we're not relitigating anything. As I said, it's about credibility. And with regard to, and this is where counsel, who supposedly knows her case, should review to her own documents. I'd like the court to see this. Regarding Officer Mazzola, we have a form, 9408-17431, which says OIC name, officer in charge name A. Mazzola, assistant name D. Fung. We don't make these things up. I'll be glad to have them look at that. It's their form. Now, we don't make these things up. And with regard to the field of special care, she says, this in quotes, that's from the LAPD form, Your Honor. Remember yesterday when we showed the form, we pulled that up, where they failed to check the appropriate box when the Bronco was left basically unattended for all those months. Now, she conceded the DNA testing did pass through LAPD. Yes, it does, Your Honor. With regard to the blood vial, Your Honor, again, that is our belief based upon all the documents we've been given in discovery. And, if it turns out wrong, that's what we're going to say. This is based upon the documents we've received. It's not argumentative. That's our position, Judge. And she can't tell us what our position is or what it should be. She should understand that right at the beginning. And then with regard to the socks, we'll accept whatever language Your Honor says about that. But again, if you look at this particular form, Your Honor, this form is entitled O.J. Simpson, Summary of Analyzed Evidence by Analysis Performed. We're using their own forms, Your Honor, by analysis performed. And it says under there that none obvious. And so that's all we've said. We took their own form. And so, there was a recent movie, Your Honor, where there's a line which I think is very appropriate in this case. I think it was A Few Good Men. We keep hearing about the truth. I don't think they can stand the truth. That's what Jack Nicholson said. That you don't want to hear the truth. And I think it's very appropriate in this situation. That's exactly what's happening here. There's one other thing I'd like to point out.
Wasn't he the bad guy? Wasn't he the bad guy?
Yeah, but bad guys say something worthwhile sometimes, Your Honor. So even bad guys tell the truth on occasion, Your Honor. Certainly we aren't the bad guys in this case, Your Honor. Your Honor, with regard to one other thing you'd ask us to do at the end of the day, and I believe this is on page 25 of Volume 2, Volume 11 of the reporter's transcript of proceedings from Thursday, July 7th, 1994. I'd ask leave of court to read this. It's Mr. Shapiro question. How much blood did you withdraw from Mr. Simpson? Answer, approximately 8 cc's. Question, when you say approximately, you did not measure the amount. Answer, well, it could have been 7.9 or it could have been 8.1. I just looked at the syringe and looked at about 8 cc's. You'd ask us to find that for you, and I'll give this to the clerk. But all we're asking to do, Your Honor, is to stop all of this haggling, and let's start with the opening statements. And we previewed everything, and I think it's time to resolve it.
All right, thank you, counsel. All right, the objection to the use of the videotape is sustained. The argument has been that the concession has been that these are snippets and that the defense is willing to take the risk in argument that they cannot lay an accurate foundation. The problem is that leads to the danger of misleading the jury, and I'm not willing to take that risk during the course of an opening statement, so that objection is sustained. As to the SOC chart, the language that is on the SOC chart comes from a summary of reports and testing. It is not the report itself. The objection is sustained as to the language, blood search, none obvious. In all other respects, the SOC timeline chart may be used. As to the conduct chart, the objection is sustained. These quotes, some of these quotes are taken out of context, and there's a danger of misleading the jury as a result, so that objection is sustained. All right, counsel, I think that, I did not rule yesterday on the, Mrs. Robertson reminded me, I did not rule on the photograph of the defendant and four ladies in formal dress.
My notes say that the court did rule, Your Honor, that
I noted I didn't check it off on my list, and Mrs. Robertson indicated I didn't rule. So the objection on that, as to that, is overruled. For the rest, so the record's complete. All right, counsel, that takes care of that. Let me just advise counsel, tomorrow one of our sequestered jurors has a medical appointment, and we will adjourn tomorrow at 3:30. 3:30. To accommodate that. And I would also like to talk to counsel at some point in time regarding your proposal regarding a scene view when you get the opportunity. All right, anything else before we invite the jurors to join us?
Your Honor, maybe
And the new chart will be people's next in order, photocopy of that for the record purpose. All right, Mr. Hodgman.
Thank you and good morning, Your Honor. Your Honor, first of all, there's a matter that we will need to approach sidebar. I think the court can handle it quickly, but it's a point of information I think all of counsel need to know before we proceed with opening statement.
All right.
Then, before we do that, Your Honor, before we do that, I'm sorry. Yesterday we raised a discovery concern with regard to the defense. This morning I've been provided with another witness statement from the defense, a memorandum from a Mr. William Pavlik dated November 2nd, 1994. I had asked the court yesterday that the court order that the defense turn over all discovery that's in their pipeline, so to speak, because we don't want to be surprised anymore. Now, I have asked Mr. Douglas this morning, is this it? Is there any other witness statement that they have, regardless of age? And I believe his response was that he could not be definitive about it. Is that correct, Mr. Douglas? All right, I'll let him speak for himself. But what I would like the court to do is to remind the defense of their obligation to turn over to us witness statements, timely fashion. We're asking that everything be disgorged, as I did yesterday. And I would like to have that order made clear for the defense.
Mr. Douglas?
Your Honor, yesterday there was a specific reference made to an interview of a Scott Matsuda, whose name was added to the witness list, and I specifically had asked my investigator for that particular report, and I asked him to check to make sure that none of the names that were added, that there were any reports that had not been turned over. That was the report that I was given. That was the report that I turned over, and I will again endeavor to review my files, to review the files of the other counsel, and to make sure that there are not any other reports still outstanding that have not been turned over. And if I find so, I'll give them to Mr. Hodgman.
All right, I would like for you to report back to the court tomorrow morning, Mr. Douglas, as to that search.
Yes, sir.
All right. All right, Mr. Hodgman, can we approach now?
Yes.
Thank you. Yes. stand in recess until 10:30, and we will begin opening statements at 10:30. All right, Deputy Jex, we need the jury, please. All right, back on the record in the Simpson matter. Mr. Simpson is again present before the court with his counsel, Mr. Shapiro, Mr. Ullman, Mr. Cochran, Mr. Douglas, Mr. Bailey, people represented by Ms. Clark, Mr. Darden, and Mr. Hodgman. The jury is not present. Deputy Magnero, may we have the jury, please? All right, counsel in the audience, please be seated. All right, good morning, ladies and gentlemen. We are going to begin with the opening statements made by the lawyers in the case. Let me remind you from my instructions to you yesterday that any statements made to you by the attorneys during the course of their opening statements are not evidence and should not be considered as such by you. These opening statements are normally given by the attorneys to sort of give you an overall view of the evidence that they intend to present. It's to give you a roadmap, so to speak, as to how to evaluate the evidence. This case, as you know, will be relatively long, and by necessity, some of this evidence will be presented to you out of chronological or logical order. So they'll need to explain to you the case that they intend to present. All right, are both sides prepared to go forward, Mr. Cochran?
We are, Your Honor.
Mr. Clark?
Yes, we are, Your Honor.
All right, do the people wish to make an opening statement?
Yes, we do. Thank you.
All right, you may proceed. Mr. Darden? Thank you.
Your Honor, Judge Ito, Mr. Cochran, and Mr. Shapiro and Dean Ullman, and to my colleagues seated here today in front of you, and to the real parties and interest in this case, the Brown family, the Goldman family, and the Simpson family, and to you ladies and gentlemen of the jury, good morning. I think it's fair to say that I have the toughest job in town today, except for the job that you have. Your job may just be a little bit tougher, but your job, and like my job, both have a central focus, a single objective, and that objective is justice, obviously. It's going to be a long trial, and I want you to know how much we appreciate your being on the panel. We appreciate the personal sacrifices you're making by being sequestered. We understand that can be difficult. And I'd like to thank you in advance for keeping the promises you made to us when you were selected for the jury initially. You promised to be fair. You promised to be open-minded. You promised to hear and see and carefully consider all the evidence in the case. And you promised to find this case, to come to a verdict in this case solely on the basis of the evidence and the law given to you by Judge Ito. And you promised to do that based on the law, based on the facts and the evidence, and nothing else. You promised us that you had no hidden agenda, that you only wanted to see justice done, and you promised us that you would do everything you could under the law to see that justice was done. And so I thank you for that, and I thank you in advance for the verdict you will at some point render in this case. And we're here today, obviously, to resolve an issue, to settle a question that has been on the minds of people throughout the country these last 7 months. It certainly has been on the mind of my people up in Richmond, California, and friends in Fayetteville, Georgia, and all across the country, and everybody wants to know, and everybody I know often pose the question to me, did O.J. Simpson really kill Nicole Brown and Ronald Goldman? Well, finally, ladies and gentlemen, I am here in front of you this morning to answer that question. And we'll answer that question from the witness stand, and from the exhibits you'll see in this case, and from the evidence. And when you see the evidence, and when you hear the witnesses, and when you put it all together and consider the totality of circumstances in this case, the answer will be clear to you as well. The answer to the question is yes. The evidence will show that the answer to the question is yes. O.J. Simpson murdered Nicole Brown and Ronald Goldman. And I'm sure you'll be wondering why as the trial proceeds on, and I'm sure you're wondering why right now. As the judge instructed you already, opening statements are not evidence. Opening statements are given by lawyers, and in an opening statement, we inform the jury of what we think the evidence will show in this case, what we believe the evidence will show. But we're lawyers. We're not witnesses. We're not under oath. Nothing we say is evidence. The things we say to you today are not the things that you should carry into the jury room and into deliberations. You should carry into the jury room and into your deliberations the evidence in the case, the testimony from the witness stand, the exhibits admitted at trial, the instructions given to you by the court. And when you look at all of that, when you go back and reflect on the testimony and the exhibits and everything you heard and saw in this case, you'll know why he killed Nicole Brown and Ronald Goldman. And when I give you the answer as I have, and you consider and you stop and consider and you think, why would he do it? Why would he do it? Not O.J. Simpson, not the O.J. Simpson we think we know, not the O.J. Simpson we've seen over the years. But that raises another question, and that question is, do you know O.J. Simpson? We've seen him play football for USC. We watched him thrash UCLA and play in the Rose Bowl. We watched him win the Heisman Trophy. He may be the best running back in the history of the NFL. We watched him leap turnstiles and chairs and run the airplanes in the Hertz commercials. And we watched him with a 50-inch afro and Naked Gun 33 and a half. And we've seen him time and time again. And we came to think that we know him. What we've been seeing, ladies and gentlemen, is the public face, the public persona, the face of the athlete, the face of the actor. It is not the actor who is on trial here today, ladies and gentlemen. It is not that public face. It is his other face. Like many men in public, like many public men, they have a public image, a public persona, a public side, a public life, and they also have a private side, a private life, a private face. And that is the face we will expose to you in this trial. The other side of O.J. Simpson, the side you've never met before. We will expose in this trial and show to you in this trial that other face, the face he wore behind the locks and the gates and the walls at Rockingham, that other face, the one that Nicole Brown encountered almost every day of her adult life, the one she encountered during the last moments of her adult life. The same face Ron Goldman encountered during the last moments of his life. When we look upon and look behind that public face, the public face of the man who sits here in court today, you'll see a different face. And the evidence will show that the face you'll see and the man that you will see will be the face of a batterer, a wife beater, an abuser, a controller. You'll see the face of Ron's and Nicole's murderer. To understand what happened at Bundy, we need to examine this defendant's relationship with Nicole. Because when we do, we can discern from that, we can see a motive. We can see his motive for killing his ex-wife. And I submit to you, ladies and gentlemen, that as the trial proceeds on, and as you hear the evidence in this case, that motive will become clear. He killed Nicole for a single reason. Not because he hated her. He didn't hate Nicole. He didn't kill her because he didn't love her anymore, because in his mind, he did. He killed her for a reason almost as old as mankind itself. He killed her out of jealousy. He killed her because he couldn't have her. And if he couldn't have her, he didn't want anybody else to have her. He killed her to control her. Control is a continuing theme. It was a continuing theme. The central focus of their entire relationship. By killing Nicole, this defendant assumed total control over her. By killing her, he committed the ultimate act of control. By killing her, no one else could have her. No one but him. And he killed Ron Goldman. And he killed Ron Goldman for another reason. He killed Ron Goldman because he got in the way. He killed Nicole because he had a problem with her, as men and women sometimes do have in relationships. They have a problem. And this defendant's problem, the man in the courtroom, I think he stated his problem rather eloquently at his weight, as he stood over her body at his weight. And he said then, and he said on other occasions, and I quote, he said, while standing over that casket, while standing over Nicole's body, my problem was that I loved you too much. But it wasn't really love, ladies and gentlemen. And this will be reflected in the evidence, and the evidence will establish this, that it wasn't really love. What this defendant had for Nicole Brown wasn't love, it was obsession. He became obsessed with her. And his obsession was so great that he developed a need to control her. And his need to control and his feelings of obsession, his obsession was so great that when he came to realize that he could not keep her, he killed her. Because to let her go would mean to lose control of her. To let her go with Ron Goldman or someone else would mean to lose control. He couldn't have her. And neither could anyone else. Now, the evidence in this case will establish that the man in the courtroom, this defendant, is an extremely controlling and possessive man. And as I said before, control and possessiveness was a single dominant theme throughout their relationship. And he controlled her in a variety of ways. He controlled her financially. When the defendant and Nicole first met, she was barely 18 years old. He was almost 30. She shared an apartment. He owned a mansion. She waited tables at a restaurant. He was a millionaire. No one had ever heard of Nicole Brown, but he was one of the most recognized men in America. But after he met her, he slowly began to control her. She shared an apartment with a friend. He got her own apartment. He bought her things. He gave her things. The time she was 19, she was driving a Porsche. He got it for her. He began to gain control over her. And throughout the years, throughout their relationship, he maintained that economic control over her, that financial control. The evidence will show that Nicole never really held a job. She never really worked. She never really operated a business. She never had an income really of her own. Throughout her entire adult life, this man, the defendant in the courtroom, held the purse strings in her life. Whatever money she got, whatever material possessions she got from the defendant. People can sometimes be bought. And young people sometimes can be easily misled. Nicole was a very young woman, if a woman at all, when she first met this defendant, the man seated in the courtroom. And as the years went on, and as they continued to date, and as he gained more and more control over her, the more control he gained, the more abusive he became. As you listen to the evidence in this case, you're going to be hearing evidence regarding domestic abuse, domestic violence, stalking, intimidation, physical abuse, wife beating, public humiliation. As you listen to the trial and as you hear this evidence and see this evidence, please keep in mind that all of these different kinds of abuse were all different methods to control her. Let me proceed on. The evidence will show in this case that he abused her mentally. He stripped her of her self-esteem. This defendant dictated the way Nicole would dress. He dictated the way she would wear her hair. And when he didn't like her appearance, he would criticize her, he would humiliate her to the point that she would cry. If he didn't like her shoes, he'd go out and buy shoes. This is what I want you to wear. Wear this, look like this. She was not a Barbie doll, ladies and gentlemen. The evidence would show that he was so controlling that he attempted to define her identity. He attempted to define who she was. When she was pregnant and put on weight, the evidence would show that this defendant was so abusive that he called her names. He called her fat. He called her a pig. And he did this in the presence of her family and in the presence of her friends. And he humiliated her. And that is the face we intend to expose in this trial. That's the other side of this defendant we're going to show you in this trial. And by doing these things and by hurling these insults, he stripped her of her self-esteem. And when you're controlling someone financially, and when they have no self-esteem, and when they have no identity, you have them. You control them. The evidence will show that this defendant, this man in the courtroom, was a very controlling and possessive man. And that the dominant theme throughout their relationship was his control of Nicole Brown. But he did more. He did more than just demean her in the presence of others. He attempted to isolate her, sometimes from some people. When certain men came around, he became jealous. And he became so jealous that it got to the point that she would not agree or want to be around certain men because she was concerned that he might get jealous by their mere presence. And as time went on, and as he became jealous, and more jealous, he even insisted that she not be around certain men. He began to isolate her, ladies and gentlemen. When her friends came around, her girlfriends came around, and when he felt that she was spending too much time with those girlfriends, he talked to the girlfriends. He let them know he didn't like them hanging around. He dissuaded her girlfriends from hanging around. He attempted to isolate her from other people. And when you isolate someone, and when you have economic control over someone, and when you strip someone of their self-esteem, and when you establish their identity, you have them. They're yours. You can control them. And the evidence would show in this case that this man is an extremely possessive and controlling individual, and that he is an extremely obsessive individual when it came to Nicole. And his obsession was manifested by the things he did toward controlling her, but demeaning her and controlling the purse strings and isolating her and defining who she would see and who she wouldn't see and who her friends would be and who they would not be wasn't all this defendant did to control this woman. There are more powerful forms of control. There's force. There's violence. There's fear. There's intimidation. And you will hear testimony. You will see evidence that in his quest to control Nicole, this defendant used all these things. He used fear. He used intimidation. And he used violence. And he instilled such a fear in her, ladies and gentlemen. She will hear testimony that he could walk into a room. He could walk into a room, and Nicole would be there. And a moment before he walked in, she would just be the most charming individual there is, relaxed. But when he walked in, her demeanor changed completely. As time went on, his mere presence became intimidating to her. I mentioned earlier that they met when she was around 18 years old back in 1977, and they dated for 8 years. And they eventually married in 1985. And the marriage was a stormy marriage. And it was a marriage punctuated by acts of violence. And that violence would always be followed by an apology. He would apologize, give her jewelry, buy her flowers. He would promise to do better. Promise to maintain control of himself. And he would promise not to do it again. And then those acts of violence would be followed by additional acts of violence, and it became a cycle. Violence, apologies, a period of quiet and calm, then violence and apologies, quiet and calm, violence, apologies. Quiet, calm. A cycle of violence characterized their relationship. It characterized their marriage. And domestic violence, ladies and gentlemen, that's a difficult topic, because domestic violence is something that happens behind the gates and the walls. It happens in the bedroom and inside the home and in places where the public can't see. Domestic violence is a private affair, generally, while it's occurring. And so it makes it difficult to obtain evidence, to gain proof that the violence occurred. And it makes it difficult to obtain evidence and gain proof that the relationship is a violent relationship. But we do have that proof. We do have proof. We do have evidence. You will hear testimony from witnesses in this case, and they will discuss the violent relationship, the violent marriage this defendant had with Nicole Brown. In 1985, the police responded to the defendant's home on Rockingham in response to a call. And when they arrived, they were met by Nicole. She was crying, and she was upset, and her face was puffy, and she was near hysterics. She told these people, she said, we had a fight. After the fight, I was trying to leave, and when I tried to leave, the defendant grabbed a baseball bat, and he took that baseball bat and smashed the windshield to my car. This is 1985. And as they looked around, these law enforcement officers, they looked to the right, and they saw a white 450 SL Mercedes-Benz. And the windshield was smashed out. And just then the defendant came out of the house. And he offered an explanation. Well, the police didn't arrest him. They left. They left Nicole there. They left the defendant there. And that isn't an act of physical violence toward Nicole, is it? Or is it? Maybe it is. Nicole Brown was there to witness this act, this violence on her vehicle. And if you're married to someone and you love someone and you have a fight with them and they take a baseball bat and they do something like that to one of your prized possessions, could it be that they're sending a message? The evidence will show that this was a message. It was an indication. It was a warning as to what would happen next. It was a warning that what happened to this Mercedes-Benz could just as well happen to you. And it did happen to Nicole. Not with the baseball bat, but just like that Mercedes got smashed and dented, so did Nicole. You'll be hearing evidence. You'll be hearing testimony. You'll be seeing witnesses in this case regarding an incident that happened on January 1, 1989. It was almost 4 o'clock in the morning on January 1st when the 911 operator received a telephone call from Rockingham. And that operator will be here to testify in court. And that operator will be here to authenticate the tape of that 911 call from Rockingham. And when the operator appears, and when the tape is played, listen very carefully. Because if you listen carefully, in the background, you will hear a woman screaming. And you will hear something else. You will hear the sound of this defendant, this man, beating this woman. You will hear the sound of his hand smacking across her face. You will hear the sound of this defendant beating his wife. Well, the police arrived. They arrived at Rockingham in response to that telephone call. Nicole never got to tell the 911 operator to come and help me or anything like that. All she did was scream, and the operator could hear her screaming, and the operator could hear her being beaten. And she advised LAPD units to respond to 360 North Rockingham. We can hear the sound of a woman being beaten now, right now. And the officers arrived at Rockingham a short time later. And when they did, they rang the buzzer to the security gate. And as they did so, they saw someone run from the bushes, run from the darkness in their direction. And this person that they saw was Nicole. And Nicole came running out of the darkness, wearing nothing but sweatpants and a bra, running toward the officers. And she was covered with mud, and she was dirty, and she was filthy. And she ran toward the officers, and as she ran toward the officers, she was shouting and yelling, "He's going to kill me! He's going to kill me!" And the officers stood there. They didn't know what to do. It's 4 o'clock in the morning, she's out in her bra. Sweatpants are covered with mud. They just got a call. There's a woman in Rockingham being beaten now. She comes running out of the darkness and out of the mud and out of the bushes. And she pushes the button to the security gate, and she runs through the gate, and she collapses in the arms of the officer. The entire time she's yelling, "He's going to kill me. He's going to kill me." And the officer said, Who's going to kill you? And she said, "OJ is going to kill me." And the officers looked. They looked at Nicole. Her eye was swollen, bruised. Her lip was cut. And one of the officers, the senior officer there, he looked at her neck. And what he saw startled him. On her neck, he could see the imprint of a hand. The imprint of a hand around her neck. Well, it was then that the defendant came out of the house. He was wearing nothing but his bathrobe. And he did not address his wife at the time. And he did not ask the police how she was doing or if she was okay. And what the evidence will show, and what you will hear in this case, is that he demeaned and humiliated her even more. He shouted to the officers in the presence of Nicole, his wife, "I've got 2 women now. I don't need that one. I don't want that one in my bed anymore." This was his wife, and this is what he said to these officers who were strangers to him. This is what he shouted out to the police. The officers were on one side of the gate of the wall, and the defendant at that time was on the other side. The officer said, "Mr. Simpson, we're going to have to place you under arrest. It appears that your wife has been beaten. So please go back into the house and put on some clothes and come with us. We're going to take you to the station." Well, the evidence would show that that did not sit well with this defendant. And he responded, "The police have been here 8 times before. And now you're going to arrest me for this?" 8 times. That's what the defendant said. The police had been there 8 times before. And as he said, "You're going to arrest me for this?" The defendant told the officers, "This is a family matter." That's what the evidence would show. The defendant said to the officers, "This is a family matter." And he asked, "Why do you want to make such a big deal out of it? We can handle it." The evidence would show that the officers did not like the way he had handled things up to that point. And they insisted that he get dressed. And they told him that he was under arrest and that they were going to take him to the station. Well, this was O.J. Simpson. And he did get dressed. But he didn't go to the police station. He jumped in his Bentley and he sped away, and they chased after him. They didn't catch him, and he got away. The next day, he went to the Rose Bowl. But despite this, despite 89, what happened on January 1, 89, despite the Mercedes-Benz incident in 1985, she stayed. She stayed with him. And I'm not suggesting, and the evidence won't suggest, that every day of their marriage or their relationship was stormy, rocky, and filled with violence. That's not what we're suggesting here. But we are suggesting, and the evidence will show, that there was a cycle of violence. A cycle of violence, and the dominant theme in that relationship and in that cycle, and the ultimate objective was always control. Control. Well, after the 89 incident, after that night, their relationship changed somewhat. She was concerned. And the defendant was concerned. The defendant is a public man, and he was concerned about his public image. And in the public domain and in the public media, back in 1989, he was interviewed by Roy Firestone on ESPN. And during that interview, Mr. Firestone asked the defendant about that incident on the morning of January 1. And the defendant downplayed it. He minimized things, fluffed it over. And you'll hear and see that interview. And in that interview, the defendant said it was sort of a mutual wrestling match. She was wrong, he was wrong. Ta-da. No big deal. And that's what he said to the press and to the public. He minimized things. But you'll hear testimony from investigators employed with the DA's office, and they'll tell you about a day just a few months ago when they drilled a hole in the safe deposit box, Nicole's safe deposit box. And they'll tell you about the day that they recovered photographs taken of Nicole's injuries back in 1989. And they'll also tell you about the recovery of some letters the defendant wrote to Nicole after the 1989 beating. And you'll see those letters. They'll be here you'll be able to read them, and you'll note that the account the defendant gave the press and the media and the public was not the same account he gave Nicole in those letters during that apology phase, the contrition phase, the phase he was going through. In the letter he wrote to Nicole, he apologized for hurting her. In the letter he wrote to Nicole, he admitted he had lost control. And in the letter to Nicole, he said the same old thing you've been saying all along, and that is that I will do better. We can get through this. And that happens in bad relationships and in abusive relationships, doesn't it? Things get bad, bad things happen. It's always somebody's fault. But nobody wants to take the blame. And in this situation, and the evidence will show that what the defendant did was he made these promises. He sort of roped her back in. You know how it is. Bad relationship, I'll do better, here's a gift, I'm sorry, and they just rope you back into it. And if you're the other person in Nicole's position, as she was, and this will be reflected in the evidence, she wanted to believe. She wanted to believe that her marriage could survive. She wanted to have hope, and he gave her hope for a while. Because this is a cycle. And so he beat her up on January 1, and he admitted to her privately in his letters that he was responsible. And he apologized, and he gave her things, and he tried to make it all better, and he gave her hope, and he roped her back in, and she stayed. She stayed because she had hope and because she wanted to believe that January 1, 1989 would be the last time that he would abuse her, physically or mentally. As you hear the evidence in this case, something very sad becomes very apparent. They met when she was 18, and he was almost 30. And in 1992, they divorced. She was only 33 or so. And she died when she was almost 35. Throughout her adult life, throughout most of her adult life, her concept of marriage and a relationship was defined by this defendant. That was adult love. Her notion of adult love for 15 years was what this defendant gave her. And he abused her throughout that relationship. Well, as I said before, sometimes you get roped in, people get roped in. Nicole got roped in by the defendant, and she stayed, and she stayed. And people stay in those situations, those abusive relationships, for years and years, until one or two things happen. One, they just can't take it anymore. Or two, until they just can't take it anymore and they wake up to reality. And finally, in 1992, Nicole woke up to the reality of her situation. And in January 1992, she moved from Rockingham, and she left the defendant, and she filed for divorce. Well, this did not sit well with this defendant, and this will be reflected in the evidence. He did not like this. He did not like the fact that Nicole was leaving his house, going somewhere else to live in her own house, away from him. There's that issue of control. How could he control her? She wasn't right there with him. And he didn't take it well, and he lost 20 to 25 pounds like that. And almost on a daily basis, he would call her sisters, Dominique and Tanya and Denise. And he'd call her mother and her father, sometimes crying on the telephone. And he would call them, and he would whine to them, and he'd tell them how much he loved her and how he wanted her back. He'd use them to try and rope her back in. Well, she couldn't let him go, not completely. I mean, how could she? She'd been under his control for 15 or 16 years. And so she didn't go too far. She rented a house in Brentwood on Gretna Green. They saw each other. They had children together, lovely children. You'll probably be seeing a picture of one pretty soon. But he couldn't deal with the loss of Nicole. He couldn't deal with not having her there. He couldn't deal with the loss of control, and he couldn't help but pursue her. You'll hear a testimony in this case from Nicole's mother, and she'll tell you about some of the telephone conversations she had with the defendant back in 1992, and some even more recent. And in one conversation, he told her, he said, all my friends tell me that I should just leave her alone, just forget about it, just go on with my own life. And when Mrs. Brown said, why don't you do that? Let her go. If you let her go, then maybe she'll come back to you. Just let her go and maybe she'll come back. And his response was, I can't. You know I can't. You know I can't help myself. I can't let her go. He couldn't let her go. He couldn't help but pursue her. He couldn't leave her alone. He couldn't handle the loss of control. And because she had left his house and moved somewhere else and established her own home, her own house, and began establishing her own relationships, he did the only thing he could do to gain control, to try to regain control, to try to find out what was going on with her. And so he stalked her. He stalked her. When she left Rockingham in January of '92 and set up a new household on Gretna Green, also in Brentwood, she began dating a man named Keith. Keith Zalamzowicz. And she got a babysitter for their 2 children. Whenever Keith and Nicole would go out, not every time, but enough, he would show up. They went to a nightclub, and Keith will tell you about this. He'll be here to testify. The defendant showed up. They went to a restaurant called The Tryst. It had just opened. Nicole and Keith and some other friends, they were there. They got a table. They began to have dinner. And as they sat there having dinner, guess who showed up? Guess who attempted to gain control again? The defendant showed up. And that'll be reflected in the evidence and in the testimony. And what he did is he walked into the restaurant. He saw Nicole and Keith and her other friends. He went to another table. He grabbed a chair. Now, the chair was facing in an opposite direction, but he grabbed the chair. He turned it around. He sat there staring at Keith and Nicole and their dinner party. Well, Keith will be here to tell you that that was an awfully intimidating experience. Why? There was another incident at the Mezzaluna. Nicole was there, Keith was there. The defendant suddenly showed up, drove up in front of the restaurant, got out of the car, walked up to the table where they were seated, put his hands on and said, "I'm O.J. Simpson and she's still my wife." Well, she'd filed for divorce and moved out of his house. But that was intimidating. And there's more. And you'll hear about the other incidents. There's more evidence of stalking in this case, and you'll hear about that. There was one evening when Keith and Nicole, they went to a comedy show, and after the show, they went to Nicole's house on Gretna Green. It was about 3 in the morning. And they were seated on the sofa in her living room. The kids were upstairs asleep. It's 3 o'clock in the morning. And Keith and Nicole made love on the couch. But they weren't alone. There was somebody watching. There was someone watching through the window. It was the defendant. At 3 o'clock in the morning, he was looking through Nicole's window, watching her make love to another man. And the next day, when Keith and Nicole were together, he walked right into her house. And he was beside himself, and he was angry. Said some very naughty things. But one of the things that he said to Keith and Nicole was that he said, "I watched you last night. I watched you and I saw everything. Well, the evidence will show that is some unusual behavior, to say the least. But the evidence will show also that this is all part of this cycle. It is all part of this dominant theme in their relationship. This is all part of his need to know everything about her, to know where she is, to know who she's with, to know what she's doing, to control her. It's control. It's all about control. And though he did not interrupt them during the middle of the act, and he didn't punch Keith out, and he didn't punch Nicole out, he still watched so that he would know. And to control her, he had to confront her with what he knew, to intimidate her, to keep her from doing it again. It's all about control. Well, over the months, Nicole still wanted to believe that they could be a family again together. And they would attempt reconciliation, and they would fail, and they would attempt again. And Nicole was as much a party to that as the defendant was. But there was a situation in October of 1993, an incident another control incident. He forced his way through the back door of her place on Gretna Green. He forced the door in. He entered her house without her permission, without her knowledge, and he confronted her, and he scared her. He frightened her, and he scared her so badly that she telephoned 911. And she asked for police assistance, and you will hear that tape, the tape of that 911 call, and you will meet the 911 operator. And you will hear the defendant in the background. This is October 1993. He watched Keith and Nicole have sex in April of 1992, And when you listen to the October 1993 911 tape, you can hear him in the background still yelling and shouting about what happened in April of 1992. But that 911 tape is a telling glimpse into their relationship. That's for sure. And it's also an example of this defendant's private side, his private space. The other man, the man in the courtroom, the man that's on trial here today. And you'll hear Nicole on the telephone talking to the operator. And as you listen to her, you can't help but discern from the tone of her voice and the things that she says that she's a tough woman, but that she's also afraid and intimidated. And not only that, but that she feels that her situation is hopeless. The evidence will show that by October of 1993, Nicole, her situation was hopeless, and she was helpless. Way back in 1989, the defendant said that the police had been to the house 8 times before and never done anything. Nicole said the same thing on the telephone to the 911 operator in 1993. Her situation was hopeless and she was helpless. And you can infer from the evidence that Nicole Brown expected or had no expectation that anyone would ever do anything to this defendant because he beat her. There was no help coming and she didn't expect any help. But you'll hear that telephone call and you will hear the defendant and you will get a true sense of the fear he instilled in her. And he didn't hit her that day. He didn't strike her and he didn't punch her. He did go through the house to see who was there. But he didn't hurt her that day. Still, she stayed. Still, they remained involved. Not only in the sense that he was the father of her children, but they still attempted to reconcile. And over the months after October of 1993, they tried to get together and they failed. They tried to get together and they failed. And in May of 1994, it was Nicole's birthday. And the defendant gave her a very nice gift, a piece of jewelry. And they attempted to reconcile, for lack of a better description. But the evidence will show that it was a very brief attempt, because a few days later, Nicole called it quits. She woke up to the true reality of her situation. She couldn't be bought anymore. She couldn't live like that, and the evidence will show that she let the defendant know that it was over. This is it. Hasta la vista. And this was significant in the mind of this defendant, ladies and gentlemen. It was something that had never happened before. He would do things to her and he would try to appease her by giving her things, and she would accept those things and they would reconcile. But not this day. This day, she couldn't be appeased. She couldn't be bought. She couldn't be bribed. She had had enough.